name is Matthew Waring, and I am a partner at Fairway Law Group. We're having another talk today about divorces and everybody's favorite topic, apparently. And I'm here with Brian Dunmire. He's my partner, and I'll let him introduce himself.
Yeah, good afternoon, everybody. My name's Brian Dunmire. Matthew and I are the partners at Fairway Law Group. I work out of the Orlando office, and Matthew works out of the South Florida, if you're familiar, Deerfield Beach, right around Boca Raton area, just north of Fort Lauderdale. And we are the owners and partners of Fairway Law Group, specializing in family law, divorces, and all sorts of family law issues. No shortage of them running through the state of Florida currently.
All right, and today what we wanted to talk about was we want to give everybody a broad overview of how the divorce process works. You know, we got a lot of people we do the consults all the time. We've got a lot of people that are on the fence about divorce. They're thinking about getting divorced. They've been served with divorce paperwork. Maybe they have, maybe they haven't. Maybe somebody's wife just told them to leave the house and that the relationship's over. Whatever it is, people want to know what to expect. And, you know, we don't have the facts of everybody's specific case right in front of us, so we can't tell any specific person what's going to happen as a result of the divorce, how they're going to end up, if they're going to pay alimony, if they have child support. We're not getting to those issues, but we want to give people a broad overview of how the process works so you know what to expect going into it.
Yeah, absolutely. And one of the first things that you got to understand, and if you're somebody who maybe owns a construction company or works in insurance and you deal a decent amount with the court system, which isn't necessarily always a bad thing. Sometimes there's just issues that arise and you have to deal with the court system. You have a pretty good understanding of principle number one of the court system, which is things don't happen overnight. Okay, it's going to take a little while for the courts to process paperwork, and that means different things to different people. We get a lot of phone calls where people want the divorce, they want it to be done, and we move it along as quickly as we possibly can, and we run a pretty efficient operation here. However, the court system takes time, and then there are certain steps along the process that takes time. So one of the first questions that we get asked is, how long is this going to last? How long will it take to get filed? And it's never a straightforward answer. But what I typically explain to clients is that the quickest that you're going to get divorced is if you and your spouse agree on everything. Okay, hey, this is how we're going to split the property. This is how we want to do the time sharing with the kids. This is how we're going to split the bank accounts. And if you and your spouse you don't want to be married anymore, you just want to go your separate ways, but you've agreed on everything, we can get you divorced pretty darn quickly. However, even in that scenario, sometimes it might still take in between about 1 and 3 months because different courts do different things. Some courts just stamp. I shouldn't say that. Some courts review the documents a little quicker than other courts. If there's no kids involved, sometimes judges are a little bit more likely to allow somebody to send in paperwork and stamp it, say, yeah, you're divorced. If there's kids involved, sometimes the judges take a little bit closer look at things. But I say that to say that it's not going to be something that you can just do overnight. It can move quickly, but it's not necessarily going to move overnight. And that's one thing that we try to explain to our clients right from the very beginning. Matt, you got any thoughts on that?
Yeah, I just want to clear up a little ambiguity. So we get people calling all the time and they want to know about what the difference is between a contested divorce and an uncontested divorce, a simplified dissolution, regular dissolution of marriage. It doesn't matter. It does not. It simply does not matter. You cannot get divorced in the state of Florida without filing a petition for divorce. That is a formal lawsuit. You have to file a formal lawsuit in circuit court in Florida in order to get divorced. You can't just go down with your spouse down to the courthouse and sign some papers and get divorced. It does not work like that. It's a circuit court action. You've got all of the rules regarding procedure, civil procedure, due process, you name it. So it is a legal action. It is a lawsuit. When you file for divorce, you're suing your spouse, essentially, or vice versa. So whether or not you've heard it called simplified or simple divorce, it does not matter. All of the same rules apply. Okay? You cannot get away from filing a case, and you're going to have to pay the filing fee. It is what it is. When you hear people say simplified dissolution, what they're referring to is a divorce in which still's got to get filed with the court, but the spouses both agree on every single detail, and there are no minor children involved. In cases in which you have minor children involved, you're still going to need to produce financial affidavits. The judge in the case is still going to have to look at the best interests of the child in granting the divorce and granting the parenting plan. If you've got minor children, you're not going to have a simplified divorce. It doesn't mean it's going to be complex. It doesn't mean it's going to be extremely expensive. It just means that it's not going to be considered simplified. Brian, do you want to walk people through a little bit how we actually go about filing the divorce cases?
Yeah, absolutely. So when Matt refers to filing a divorce case, again, for those of you who aren't familiar with the court system and everything like that, it can be a little bit overwhelming, a little confusing. So at the basic form, there's two different types of courts. There's the state court and the federal court. We don't need to worry about federal courts. That's for the U.S. government, patent stuff, things of that nature. It doesn't have anything to do with divorces. Divorce is all filed in state court. State court in Florida, we have 67 counties. So you're going to file for divorce, most likely in the county that you live in. There's a few ways around that. If you and your spouse are separated and your spouse lives in the next county up and they've lived there for 6 months, you could file in either county. But typically it's going to be the county that you live in. It's just the safest, most general explanation of it. Essentially, two requirements to get divorced in the state of Florida. You need to be married and you need to live in Florida for at least 6 months. We don't really run into the marriage issue too. Typically, people are already married when they're calling us for a divorce. We do from time to time run into the 6-month issue. And if you're on the receiving end of it being told, hey, we can't file for a divorce just yet, it can be a little bit frustrating, but it actually makes sense when you think about it because the legislator doesn't want people moving to Florida for one day from a Montana or Wyoming or California or something just because Florida's laws might be more favorable to their scenario. So the legislator says, no, you need to be a bona fide resident in Florida for 6 months. You got those two things, you can get divorced, no problem. You go down to the courthouse. As attorneys, we do it all online. If you don't have an attorney, you might be able to do it online. If you create an account with it's called the Florida e-portal. It's very cumbersome. It's a little bit confusing still to this day. And Matt and I have been doing this combined over 20 or 25 years. But we file it online, so it's all electronic. And we file a number of documents. The most basic document is going to be the petition for the dissolution of marriage. That's going to be the actual document that says, I, Brian Dunmire, want to get divorced. File it. Then there's a host of other documents you need to file. You need to file a summons, which we'll go over in a second. You need to file a notice of related cases. If there's any other cases, maybe there's a child custody case over on the right hand, or God forbid, there's a domestic violence case over on the left hand. You need to give the court notice of that. There's related cases. If there's kids involved, you're going to need to file what's called a UCCJA. That's the shorthand for it, Uniform Child Custody Jurisdiction and Enforcement Affidavit. It's a mouthful. It looks very complicated on the sheet of paper when you're looking at it, but it's the basic information regarding where the child's lived, name, date of birth, and where the child has lived for the last 5 years. And there's a few other documents, and there's the social security number, things on that nature. One last thing I'll say, and then I'll turn it back over to Matt, is the summons is very important unless you and your spouse are agreeing to the divorce. If you're agreeing to the divorce, then typically your spouse will file something at the same time that you're filing or a day later. It doesn't need to be the exact time, but at some point your spouse will just say, yeah, that's fine, whatever, here you go, file it with the court system. But if you and your spouse are not getting along, or it's the contested divorce that we all hear about, what you're going to actually have to do, and this is an old rule, it's one of the most frustrating parts of our job. It's the part that slows the cases down, and I wish I had a better answer for it, but it makes sense, is you still, after everything's filed, the clerk's going to issue what's called a summons, which is just a sheet of paper that says a petition for dissolution of marriage has been filed, and it gives the other person notice that a petition was filed. And what you have to physically do is you have to, in some way, typically it's through a process server, is hand everything that you filed physically, print it out to your spouse, the opposing party, whoever it might be, whoever you're filing. This is true across all lawsuits. whoever you might be suing or filing a petition against, you have to physically hand them that document like we're in the 1800s. And that is what the court system requires you to do to make sure that they have notice of the lawsuit, because notice is a huge thing. And you have to make sure that's done correctly, because if they don't get proper notice and then they don't file anything in the lawsuit, or the petition for dissolution, I should say, and the court grants your judgment, and then in 3 years they say, I was never served. Well, guess what? There's an argument you're still married, and it's going to create a mess for you. So you want to make sure that that's done correctly.
And the other really important thing is, if for anybody out there that's trying to do their own divorce case, file their own pleadings, that initial petition for dissolution of marriage is critically important. There's forms available from the Florida Supreme Court. They post them on their website. They're pretty self-explanatory. However, it's very important that for our cases, when we file a petition, we plead for everything. We throw in everything but the kitchen sink. We plead for alimony. We plead for child support. We plead for partition of a marital residence. You name it, we put it in there. It does not mean that we are trying to blow up the case. It doesn't mean that we're trying to make the case more complicated than it needs to be. It doesn't mean that we're trying to file a very contested case. That's not it at all. But you just never know what's going to happen in the course of litigation in the divorce process. Tensions might flare up. You might discover, your spouse has hidden money stashed away, or that income's different than what they've been reporting to you, whatever it is. If you fail to include specific requests for relief and specific allegations in that initial petition, then a judge is not going to grant you that relief in the future. You have to go through the entire amendment process, and that can be costly, and especially if you don't know what you're doing. So, a lot of people, when they get served with divorce paperwork, they automatically think, oh, my spouse is out for blood. That's what you hear. We hear it in the consults. My spouse is out for blood. I received the divorce petition, and they want alimony, and they want lump sum alimony. They want bridge the gap alimony, and they want 100% of the time sharing with the kids. They want 100% custody. They want child support. Don't get into a frenzy when you receive that divorce petition, because those things are pled in there on purpose to make sure that we preserve the person's entitlement. It does not mean that that is in fact what they're seeking in a divorce settlement agreement or in a divorce final judgment.
Yeah, and this is actually something, if you ever see in the news, man sues Universal Studios and says he was injured for $75,000, okay? As attorneys, we always laugh about that, because $75,000 is a threshold, $50,000 is a threshold, and when you sue somebody for damages, which is completely different than divorce, but you have to include basic allegations, and one of the allegations is that your claim is worth over X amount of money. Could be worth a lot more. Maybe isn't necessarily worth as much, but it's something that you have to do. And the reason why you do that is to what's called invoke the court's jurisdiction, which if you're not a lawyer, you don't need to worry about. But it essentially means, hey, court, I'm asking you for relief. Here's the reason why I'm asking you for relief, in the form of a dissolution of marriage, in the form of I want alimony, I want the marital property, I want the majority time sharing. And it's got to be in there, because if you remember what I just said about the summons and how it's old rule that you have to physically hand it to the person so that they have notice of the case, right? Then it's kind of the same thing, same-ish theory of the petition. You need to specifically delineate what you're requesting. So if you don't request that you want the marital house, this isn't I don't want it today, so I'm not going to put it in there. This is, do you ever think there might be a chance that you want the marital house? And I'm going to tell you, as an attorney, maybe you're an attorney in the future, the answer is yes, okay? Because you never, first off, even if you and your spouse are getting along and you don't think that there's any universe that you want that spouse, you never know what's going to happen, good or bad. It could be something crazy, okay? God forbid, an airplane accident. I mean, just so many things that aren't even in your realm. So what we want to do as attorneys is make sure that we took all the spaghetti and threw it at the wall, because we can always dismiss it. It's not, or we could always chip away at it. We can always say, okay, yeah, we asked for alimony, but we're not entitled to it, or you don't want to claim it. Oh, we asked for the marital house, but we know that y'all are going to split it. Everything's hunky-dory. No problem. However, if you don't ask for that marital house, or you don't ask for, the joint bank account, so to speak, okay, and then we're a year and a half, and, let's find out that things change. You find out that your spouse was cheating on you for 10 years, and all of a sudden emotions start running high. You say, screw it, I want the marital house, which you're entitled to. Not necessarily because they cheated, but you're entitled to ask for the marital house. If it wasn't in the initial petition, it's going to be a royal pain in the butt to go back and amend the pleadings. And ultimately, it's going to cost you a lot more money because your attorneys are going to have to do a lot of work. And there's no clear set for you to be able to go back and add something or change it. But it's kind of one of these things where the longer the case goes, the more difficult it becomes. So, if you forgot to put something, and where we see this a lot is where people call us up and say, I filed a petition for dissolution of marriage by myself because my husband and I, or my wife and I, were getting along. My wife got an attorney, and I don't know, I got all this paperwork. I have no idea what to do. So now I feel like I need an attorney. We can probably go in there, fix anything that's missing, no problem, because it's at the beginning of the case. When we get that phone call a year and a half in, hey, I got a trial. First off, we're probably not going to take the case because it's so far in. It's very difficult for an attorney, whether it's our firm or any other firm, it's very difficult for a firm to step in on the eve of trial. So if you're thinking about getting an attorney, get one sooner rather than later. You're not going to save any money by hiring one at the last minute. But if, we get that phone call, hey, my case has been pending for a year and a half. I was handling it on my own, but now it's just to a point that I can't do it anymore. It's very difficult and very costly to go back and try and clean it up, because then it gets to a whole notice thing, right? This is where notice is so important. If a party's been in a dissolution of marriage case for a year, year and a half, 2 years, maybe even longer, and they've never had notice that you want alimony, and then you're 3-4 weeks from your trial, and all of a sudden you say, I want alimony, I don't really like my spouse anymore. The time to do that was 2 years ago, not now. So that's why if you're filing a petition and you're working with our law firm or a different law firm and you see them asking for everything, they're not trying to make anything more difficult necessarily than it should be. And if you get served with a petition and it looks like they're asking for everything, I can't speak for everybody, but your spouse probably isn't necessarily trying to make it any more difficult than it is. It's just how we do things as lawyers.
Yeah. And then, so once the petition is filed, Brian already talked about service a little bit. Once a petition is filed, we have to send out the petition, all the initial documents, and the summons that's issued by the court. We have to send that out to a process server. That process server does not work for our law firm. These are independent contractors. They're all over the state. We use different companies. If you're doing it yourself, you could Google and find one and hire one. They're not too expensive. They do a pretty good job under the circumstances. And, then we get service of process. And that can kind of slow down the case a little bit because sometimes people are difficult to serve. You got to think, these process servers are making maybe $50, $75, $100 per petition that they're getting served. That they're serving, right? So if you're getting paid $75, what are you going to do? You're going to drive out to the person's house. You're going to knock on the door. If they don't answer, you leave. You might come back a few days later when you're back on that same route and try again. If the person still doesn't answer, you come back several days later and you try again. Some people, we get service in 48 hours. Some people, it could take several weeks to get service. But the lawsuit does not, even though you filed it, there are no deadlines yet until you get service on your spouse. Once the spouse is served, they have 20 days to respond to the petition. And during that period of time, that's when they're typically going out, interviewing lawyers, trying to find somebody They might try to file a response themselves. They might hire a lawyer. The lawyer might file a response. That 20-day deadline, that's a real deadline. If you don't file a response within that 20 days, you could be defaulted, meaning that, the court has determined that you have been served, but you failed to respond. So we're just going to move on with the case without you. And you're not going to have any defenses, and the other spouse is going to get everything that they're asking for because you didn't step forward to defend the case. So it's really important that people get that response filed on time, 20 days after service. That includes weekends. It's not just business days. It's a hard and fast 20 days in order to get a response filed. When we get a client, somebody who's been served with a divorce, and the first thing we do is we determine, okay, when did you get served? And then we put in a calendar entry, this is the due date. And then we start interviewing that client, and we talk to them, and we ask them about what's going on in the marriage. We ask them about what's important to them, what their goals are, and we draft a response. But a lot of times we also will file a counter petition with our response to the initial petition. The reason why is because you're answering and you're just admitting or denying certain allegations in the original petition. But you, the one being served with the divorce paperwork, you also want to plead and request for relief. You might want alimony. You might want the marital home. So we often, in most cases, file a counter petition. Now, since you've already been served and the other party's the one that filed the initial petition, we don't need to get them served with the counter petition. We just file that with the court using the e-filing portal. Once they receive that, they have 20 days to respond as well. And then assuming that they respond on time, we say that the pleadings are closed. That's when the lawsuit, the petition's been served, there was a response, a counter petition, a response to the counter petition. Now we are into the meat of the divorce case. Now we get into financial discovery. And Brian, you want to talk a little bit about mandatory disclosure?
Yeah, for sure. Let me just kind of take a step back though. If you're listening to this podcast, you're probably at a point that you're considering divorce. Maybe you're in the middle of divorce and you're just kind of seeing, what else is out there, get some more information. Or maybe you just got served with paperwork. Or maybe you know that your spouse just filed for divorce. But if you're listening to this, you're probably, unfortunately somewhere in the divorce context. Let me give you one tip of advice when it comes to service of process. If your spouse has filed for divorce and you know that they're trying to serve you, don't avoid service. Just don't do it. You're going to ultimately get served. Okay? You're not going to, there's no benefit. First off, let me take my attorney hat off and just speak like a human. Obviously, your spouse doesn't want to be married to you any longer. And you might be having a hard time understanding that, and that's fine. It's an emotional roller coaster. I get it. But they have gone to the point that they filed for divorce. They've probably made the decision they want to get a divorce. Every now and then people reconcile. I get it. But avoiding service of process, hiding behind a table when the process server is knocking on the door, it's not going to end well. Okay? It's not going to end well. And sure, maybe you avoid service for 1 or 2 days. Okay, great. Then what? You get served. You got to deal with it anyways. Maybe you avoid service for 3 or 4 months. You might think that you're pulling one over, but you're not. Because guess what Florida has? It's called vexatious litigation. That's a very broad term, and it means when you've taken a position in the litigation that increases cost, expense, delay, things of that. Another word would be frivolous. You've done something frivolous. Well, avoiding service of process for a day or two, it's a giant pain in the butt, but it happens. Whatever. You're probably not going to get sanctioned for that, but you shouldn't do it to start off with. But if you're this guy that's avoiding service for 1, 2, 3 months, you see the process server come in and you run out the back, and the process server goes, I saw a guy running out the back, here's my affidavit of non-service, da-da-da-da-da. And you do that, it's documented, all these service attempts and everything like that. You're ultimately going to have to answer for that, because what we'll do as attorneys is we'll say, look, we understand that we filed the petition and our client has to get the other party served. That's fine. That's part of the process. There's no problem. However, it took us 2 months to get served, but it wasn't because it was just sitting on our desk or it didn't get sent out. The process server tried 16 separate times, but they'd see the guy behind the door, and he would hide, and it's all documented and everything. And just like if you're watching this online, or if you're listening to it, you're going to be sitting in front of a judge, and the judge is going to look right back over at you and say, "What are you doing?" And then you're not going to have a great answer. It's going to be very awkward. You're going to immediately lose some credibility with the judge, which we'll get into this in later podcasts. But family law courts are courts of equity. They just want to do what's right and proper. Credibility is everything. I mean, you want to stand in front of that judge, say, "I've done every single thing that I'm supposed to. What more can you possibly ask of me?" Okay? And the judge is going to say, "You know what? You made Dunmire or you made Waring spend 4 hours. So I'm going to award attorney's fees at $400 an hour. That's $1,600 that you're going to have to write a check to them because your ex-spouse had to spend that money to get you served." Don't avoid service of process. It's just, you're going to get served. It's going to happen. Just accept it and move on. Simple as that.
What we do in some of our cases is, if we can't get somebody served at their home where they live, we might have to send the process server out to their place of employment where we know they're on the clock, or where we know they're in their office. And if you're avoiding service of process at your house, then you're going to start to expect it at your office, which can be awkward. We don't like to start off and serve people at their office, even if we have a client that comes to us and says, "I want to get my husband served at his office." We don't do that, okay? There's a couple of reasons why. Number one, that's just not a cool thing to do. Number two, and we're not interested, we're not involved. You cannot hire us to punish a spouse. You can hire us to get divorced and get what's fair, but we're not in the business of punishing people, and we don't want to get people embarrassed. However, we will get people served at their place of employment if they're dodging service of process at their house. The other reason is we don't want to put anybody's job in jeopardy, even if it's not our client's job, it's the spouse's job. If there's minor children, what if you get them served at their office and they get fired? Well, that's gonna adversely affect the children. So we're not interested in that. And then ultimately, if we can't get somebody served, if somebody is avoiding service and we can't get them served at their house or at their place of employment, we'll just publicate it. We'll just publicize it. You can get service by publication. So ultimately, you will get served. So yeah, Brian's right. It makes you lose credibility. It makes you look foolish. It makes you look desperate. So yeah, don't avoid service of process. Take it on the chin and get the process started. Once service has been done, once you've gotten service, and we've already talked about responding to the petition. The next big thing, and this is the biggest issue in every divorce case, this is what people hate the most. It's the most intrusive part. It's necessary in every case. It's the subject. Brian and I have spent countless hours building softwares, building systems, processes to try to make it easier for people. It's mandatory disclosure. So Florida requires, in every divorce case, mandatory disclosure. It's not optional disclosure. It's mandatory. And it's written in the statutes. After service, whether you filed the petition or whether you've received the petition, it doesn't matter. Once somebody's been served with that initial petition, both parties, both spouses, have 45 days to disclose all of their finances. It's 3 years of tax returns, a year of bank statements, credit card statements, mortgage statements, life insurance statements and contracts, health insurance, car insurance, anything financial, you name it, it's going to have to be disclosed. And we try to work with our clients and we kind of hold their hand through the whole process, and we try to make it as easy as possible. But at the end of the day, it's got to be done in 95% of cases. And we will talk about the exception in a moment. But, a lot of people, when they're getting divorced, they're really worried about the cost and how much they're going to have to spend on lawyers. And, we get it. The portion of your case where you can save the most money and prevent your lawyer from doing the most work and actually move your case forward to conclusion is By taking the mandatory disclosure seriously and doing the legwork of getting all of the requested records and financial documents and helping to fill out your own financial affidavit, if you go through the effort to do all of it yourself, you're going to save a lot of money on attorney fees. If you don't do it, what's going to happen? If you just say, screw it, I don't want my spouse to see my checking account statements, I'm not going to do it. Well, the other side is going to move to compel and force you to do it. And the judge is going to enter an order giving you a specific amount of time to comply and produce the documents. And if you don't do it, the judge can hold you in contempt. The judge can throw you in jail for not complying. You have to comply with mandatory disclosure. And that is also where you can save the most money by doing a lot of the work yourself. You know, when we get a case, we send the clients an email with a list of all the documents that we need in the time periods that we need them. And, you know, then we'll follow up with our clients to make sure that we're getting the documentation in. We have internal checklists where we can kind of record the incoming documentation so we know when we've completed it or not. And again, each party has 45 days to do that. Now, you can move and ask for an extension, and extensions are given in a lot of times, but even if you get an extension, it might only be 2 weeks. So really, the best thing to do is to get that mandatory disclosure done within that initial 45-day period. You know why? Because it's going to give you credibility. It's going to save you money. Your lawyers aren't going to have to hound you down, chase you around town to get the information they need. Also, it gives you an upper hand because when you get your mandatory disclosure done on time, but your spouse hasn't, well, now your lawyer can file motions to compel against them. They can file motions for sanctions against them for not complying. And then it can make them lose credibility. So you want to be, whether you filed the divorce or whether you're on the receiving end of it, you want to get those disclosures done as soon as possible.
Yeah. So a couple of thoughts on that. Number one, just some common terminology. It's mandatory financial disclosure, okay, which is what Matt was just talking about, mandatory financial disclosure. Also referred to maybe as every now and then, we try not to use lingo like this, but MD, MFD, mandatory disclosure, mandatory financial disclosure, maybe even just disclosures or financial disclosure, something along those lines. They're all the same thing, okay? And included in that are two things, and they're different, but they get grouped together. A financial affidavit, which is going to be required in virtually every single case unless there's something going on, but it's much more the exception than the rule. And then the actual mandatory disclosure, which is Florida Rule of Family Procedure 12.285. If you want to Google it and look at it, it's got the list of everything. I mean, I should know the exact number of documents off the top of my head. I don't. I want to say it's 20 or 25 different categories. It's invasive. Okay. It's invasive. Credit card statements for months, years, tax returns, W-2s, depending on your complexity of assets, trusts, deeds, mortgages, bank application, notes.
Business tax returns. K-1s. Yeah.
K-1s, prior child support orders, if there's some other case going on. Tons of stuff. Okay. Now, people don't like it. But as Matt said, it's called mandatory disclosure, not optional disclosure. And let me give you a little tip of advice here. It ain't going away. Okay? It is what it is. So go back to, kind of the theme of this. Notice, right? You have to get the summons, and you get served with the summons, and then you have 20 days to respond. One thing that I tell any client who I have a consultation with where I know they got served is whether you hire us or not, you need to know one thing, and that is you got 20 days to respond. Sticking your head in the sand ain't going to make it go away. It's going to make things a lot worse for you, okay? That's the same thing with mandatory disclosure. We can send you an email. We can send you a letter. We can give you a phone call saying, hey, we need your tax returns for the last 3 years. Hey, we need this credit card statement and everything. Yeah, I'm getting you. I just need some more time. Guess what? We need it. And the case stalls if we don't have it. And not only, for an amount of time, it will stall until the other side says, hey, we got to get this case moving. And then we get into a motion to compel. Judges don't like it when cases stall because it makes the cases stay on the judges' calendars. Judges hate cases just sitting on their calendars. Not a good scenario to be in, okay? Mandatory disclosure can be simple, relatively speaking. If maybe you're a little bit younger, not a huge wage earner, no trust, no real estate plan, maybe you just have one Capital One credit card or something like that, relatively easy. Pull your documents offline, send it in, you fill out an affidavit. Hey, I paid $800 in rent. I make $1,600 a month working at Publix, whatever it might be. No problem. Send it in. It can also be extremely complex. You've got multiple LLCs, you've got multiple businesses, you're a partnership, you've got K-1 returns, things like that. In the more complex cases, that's when you start looking into, okay, well, do we need to go ahead? Should we work with your accountant? That might be a really easy way to just get everything, because in theory, an accountant should have most of the stuff. There might be a few things here and there. They might not have your actual credit card statements, but maybe your bookkeeper does. So we can do that on more complex cases, and it makes sense to do that on more complex cases. On the easier cases, the less asset cases, sometimes it's a little bit more straightforward if it's just one credit card here, one checking account statement there. Now, forget the rule, forget the technicalities, forget time frames and everything like that. Let's get to the meat and potatoes here. Why do people not like mandatory disclosure? Because on your debit card statement, there's going to be a $14.99 charge from 7-Eleven at 7:28 p.m. on a Wednesday. And when your wife sees that, she knows that it's you buying a 4-pack of Modelo's. Okay? I get it. No problem. Maybe there's some charges from some websites that you otherwise don't necessarily, aren't proud of or whatever. Let me tell you something. And I mean this in a good way. Okay? Trying to make a little bit of light of this situation. That's between you and your soon-to-be ex-wife or your soon-to-be ex-husband. Okay? The court does not care that you have an OnlyFans subscription. Okay? They don't care. That's one of the beautiful things about the Florida court system. And of course, there's always caveats to everything. God forbid there's some nasty allegations going on, or that's the exception, not the rule. In 99.9% of cases, court doesn't care that you have an OnlyFans website. Court doesn't care that you have a secret tobacco addiction that your wife doesn't know about. Court doesn't care that the wife is off having a little bit too much to drink at the wine bar, as long as there's not kids. Nobody cares about that stuff. Okay, Florida. That's one of the beautiful things about the Florida court system is we are a no-fault state. You want a divorce, you can get a divorce. Emotions don't matter. Okay, Florida says file the paperwork, give us your money, the filing fee. We'll get you divorced. That's the way that the Florida court system is set up. There are always exceptions to the rules. There are always different ways to view things. But generally speaking, nobody cares that you spent $47 at Ale House, on Monday nights, watching Monday Night Football or whatever it might be. Nobody cares. Nobody cares. Don't worry about it. Don't lose sleep over it. You might get some nasty text messages from your spouse when they see it. But hey, let's make light of the situation. That's why you're getting divorced. Okay? So, Matt, do you tend to agree, or do you have a different view of it?
No, 100%. And, what's the purpose of mandatory disclosure? The purpose is you both, you and your spouse, you both need to get audited. You both need to get audited first before we can start dividing what is marital asset or not. We need to see the patterns of spending. We need to see the income coming into the accounts. We need to see what type of assets and what type of liabilities are involved in the divorce, the lawyer on both sides. Because what we have to do before we can settle a case, we have to categorize certain things as marital assets, as non-marital assets. We got to look at savings accounts and find out, when did money come into the savings accounts? Did they come in before the marriage? Well, we can argue that a portion of that money in the savings account is non-marital, which means that you get to walk away without splitting it. There's a lot of good reasons for mandatory disclosure. So it is an audit. You're going to have to produce this information. The sooner you do it, the better. gives you a lot of leverage in the case if you're the one that does it first, and it saves you money. Don't worry. Don't be embarrassed. I mean, we've seen it all, and I can't even remember anybody's specific purchase history or anything. I mean, there's nothing that even comes to mind. It's just in and it's out. So, but after we get the financial discovery done, the financial disclosures done, then we have a period where we reflect on them on the opposing party side. So let's say we're representing the husband in a case and we've done the mandatory disclosure, and the wife files her mandatory disclosure, and we get to look at her account statements, we get to look at her financial affidavit. We send that our client, the husband, and we have a call and we say, do you see anything on here that's out of the ordinary? Does it look like she was dissipating marital assets? Does it look like she was shuffling money around? Does it look like, what if you knew that she had a job, a full-time job, and you see the income coming into her Chase checking account, but then, 2 months before she filed for divorce, you're not seeing that money coming in to the account anymore, but you know that she's still working. And in none of the disclosure materials do you see that salary coming in. Well, that's going to tip us off. She's opened up another bank account, right? That they're not disclosing. So mandatory disclosure is not complete once it's filed. We then have to review it, and we have to determine what's going on with the finances. Is anybody hiding money? Is anybody dissipating assets? Who's incurring the liabilities, and that sort of thing. That's when we make a judgment call in cases of whether or not we want to get a forensic accountant involved. If it's a higher net worth divorce case, if there's businesses involved, certain things need to be valued. We might talk to our clients about getting an accountant involved. But if it's recommended, it's usually in the client's best interest to do so. But after we're satisfied with the quality of the disclosures, when we think, okay, first of all, there's no financial affidavit or mandatory disclosure that's 100% correct. I mean, we like to think that the ones we file are 100% correct. If you go through any of it with a fine-tooth comb, you're going to find one or two things that might not be completely accurate. That's not to say that anybody's purposefully trying to mislead, but you're just dealing with a lot of facts, a lot of numbers. I mean, it's not going to be 100%, but we're going to try to make sure that both parties' mandatory disclosures are as close to 100% as possible. Once we're there, now, at this point in the case, now we can start running numbers. Now we can start talking about outcomes. Now we can start calculating child support and alimony and equitable distribution, and start coming up with ways to do some horse trading to make sure that you can keep the house, or that you can keep the car, or that you can keep your business. We can't even begin to start analyzing any outcomes until the financial disclosures are done. And it's at that point in the case, when the case is ripe, like a banana, for mediation. Okay? When both parties have done all their financial disclosure, we've gone through it, we've reviewed it, we've run our scenarios, we have our little equitable distribution models, we have our child support guidelines, we have our alimony schedules. Now we're ready to mediate the case.
Yeah. And that's one of the most, again, kind of frustrating. There's a lot of frustrating parts as being a family law attorney, because there's things that are outside of our hands that we can't handle or control, or that we see that is unfair or whatnot. But that's one of the most frustrating points is, hey, I just want this to be done. Well, a lot of times we still need your financial disclosure, because once we get the financial disclosure, then we can schedule mediation. Lots of family law cases resolve in mediation. Okay, I don't know what the percentage is, but there are a lot of family law. I mean, 50%, 60%, 70%, because ultimately cooler heads will prevail. And we can talk about this later on in different podcasts, or we will talk about this later on in different podcasts, but you want to make the decision. You don't want a judge making a decision for you unless it's absolutely necessary. And so hopefully, if you're with us, we'll be telling you this. If you're with a different law firm, hopefully they're telling you this. Try and settle a mediation. Okay? You have no point to prove. Nobody is proving a point by dragging out a case, by dragging your spouse through the mud. You're not going to get anything for it except just a fat bill from your lawyers. Okay? no matter how fairly your lawyer bills, if your goal is just to drag your spouse through the mud, you're going to get a massive bill from the lawyer. And if it was baseless, you might get a massive bill from your spouse's lawyer too. Okay, so that's definitely something to remember and think about. Mediation. Mediation's great. We love mediation. Easiest day that you'll have, in the sense that you don't have to do anything except show up and just engage a little bit. You're not under oath. There's no testimony. Nobody's questioning you.
It's confidential.
It's confidential. It doesn't leave the room. One of the good things about COVID is virtually all mediations are done remotely now. You don't even need to go to the mediator's office. You used to have to go to the mediator's office. It was a giant mess. But now almost all of them are done virtually. We prefer them to be done virtually for a number of reasons. And you go to mediation. I'll jump to the end. A successful mediation is when both people are pissed off, because it means that you gave a little bit more than you thought you would, and the other person gave a little bit more than they thought they would, so we met in the middle. It's best mediation. Okay? Here's the thing, though. Going back to mandatory disclosure now. You really can't have a mediation until mandatory disclosure is done. So you might think, well, let's get a mediation on the books and we'll get the mandatory disclosure completed. Don't want to do that. Okay? I've done that before. All right, on both sides, in complete candor, on both sides. Okay? I got my mandatory disclosure in before the mediation because that's a courteous thing to do. But mediation is a wonderful tool that we use as attorneys. But it costs a little bit of money because you got attorney time, you got the mediator time, but so many mediations resolve the entire case. It's the best money that you're going to spend, okay? Because you pay a little bit more than you'd like, but to the attorneys for attorney fee time and everything. But in one day time, you get your mediation settlement agreement, a parenting plan, time sharing, child support calculations, da-da-da-da-da. So you write the check, it's done with, and your case is done. Okay, mediator submits everything to the court. We could do an entire podcast just on mediation. However, you don't want to schedule a mediation until you have the mandatory disclosure. And you can't schedule, it's not great practice. There's certainly always exceptions, but it's not great practice to schedule a mediation before you have the mandatory disclosure, because inevitably what's going to happen is the other side's going to give you the mandatory disclosure, on the proverbial eve of mediation, the night before, or even a week before. And you're going to know that your husband has a Truist banking account, has a South State banking account, has a Bank of America account, has a Capital One Quicksilver card, has an American Express Platinum card, and you're going to be sitting there. You're going to be so excited to get it. You're finally going to see, how much money's really in that Truist banking account, and then you have your mediation scheduled, and they give you the mandatory disclosure, and you're 1 week before mediation, and you get the mandatory disclosure, and guess what's missing? The Truist account and the South State account. But maybe your husband got a South State statement sent to the house a week before, so it exists. It just wasn't disclosed. Whether fraudulently, not fraudulently, that's a different conversation, but it's not disclosed.
And mediation, like Brian said, it's a wonderful tool. It is worth every penny that you're going to pay for the lawyer and the mediator. It's worth it. It's where you can get the bulk of your case resolved. However, what you don't want to do is mediate twice. You don't want to mediate before you file for divorce. You don't want to because you're going to have to mediate again, most likely inside the divorce case. What happens if you book a mediation and then before financial disclosures are done, and then you get the financial disclosures on the eve of the mediation, and then you see discrepancies and you realize that this is not full and fair disclosure? Well, now you've got this mediation that you're going to go to, and that you're not in any position to actually reach a settlement at the mediation. So then you incur all the costs, and you always have in the back of your head during the mediation that there might be something out there, there might be something missing. So you're reluctant to agree to anything. And then what happens? You leave mediation, you got to do some more discovery, maybe take some depositions and kind of ferret out what's going on with their disclosures. And then you got to come back to mediation again. Doesn't make sense. You don't want to try to do that twice. So before you go to mediation, you want the full financial disclosure. There will be situations where your lawyer may recommend that they conduct a deposition of your spouse to go over the financial affidavit, to find if there's any other additional accounts out there. It's a case-by-case basis. It depends. You want to do all that before the mediation. And then ultimately, if we settle the case at the mediation, you're going to leave the mediation that day with a signed marital settlement agreement. If you have children, you're going to leave with a signed parenting plan. You're going to know exactly what you're getting, who's getting what, and then guess what? When you leave, then your lawyer just schedules a final hearing and gets the divorce entered, and that could be in as little as. If that, sometimes you could just mail it into the judge and the judge will sign it. So once you get done with that mediation, you're done. So if you are one of these people that are just can't imagine anything worse than spending money on a lawyer for a divorce, and you want to keep the cost low, what you do is you make damn sure that you disclose all of your finances, that you do an accurate and truthful financial affidavit, that you do the majority of the legwork in getting those documents in, and you do it before mediation. And if your spouse does the same thing, then you're going to both show up to mediation in good faith. You're going to work out a deal. You're both going to leave somewhat pissed off, but your case is going to be settled. It's going to be done. It's going to stop the bleeding, and you're both going to be able to move on. If you want advice on how to make a divorce more expensive, how to make it take longer, it is very, very simple. It is very simple. Step one, don't do your mandatory disclosure and make the other lawyer and make the court chase you down to get the information. Number two, provide inaccurate information on your financial affidavit, on your financial disclosure, so that when you get to mediation, you're not mediating in good faith and the case doesn't settle and it results in an impasse. And that's going to force them to take your the other side to take your deposition, right? And engage in other discovery. And then have to file motions to go and get their attorney fees back for having to chase you down to get accurate information. And then mediate the case a second time, refuse to settle, take your case to trial and lose because you have no credibility with the judge anymore because you've been obfuscating the whole process. That's how you make a divorce more expensive. That's how you make it take longer. If you want the quickest, simplest, cheapest divorce, just gather all your financial information, be truthful, don't omit everything, get it to your lawyer, go to mediation in good faith, reach an agreement that you can live with, and you're done.
A couple of things. I had a mediation the other week. We settled out the mediation at whatever time, say 3 or 4 p.m. or whatever. I had a final judgment at 6 a.m. the next day. Case was done. That's definitely one of the faster ones, but so anecdotal, but nonetheless. All right, let's kind of go back on mandatory disclosure for a second, because you said something that might be kind of interesting for people to hear. What about the juicy stuff in mandatory disclosure? The stuff that really does matter. Okay, so let's just say that you were having that affair in Costa Rica, or you do have a baby mama down in Miami, or you have a sugar daddy, but you're the sugar mama, whatever it might be. Okay, you're paying $2,000 a month for a condo, or you're going to Lake Como in Italy with your mistress and staying at the Four Seasons, and there's a $15,000-$20,000 credit card charge. All right, it happens all the time. Okay, $100 here, $100 there, whatever, nobody cares. Okay, $15,000 charges at Four Seasons, that's going to be a red flag. All right, little tip of advice, it's going to come out. Okay, unless you and your spouse agree on everything and it's a matter of pushing the paperwork, you're still going to need to do financial affidavits. But if you all disagree on everything, then maybe you can get away with it. But if you don't agree on everything, and when I say everything, I mean everything, it's going to come out. So this is something that we deal with as lawyers all the time, are the adverse facts of a case. Okay, that's what we do. If every case is perfect, we'd probably still have a job because people would still fight, but it would make our jobs a lot easier. Okay, I can confidently say that the number of perfect cases that I've worked on is probably zero. Judge,
that's impressive. That's impressive.
Yeah,
I'm still waiting for mine.
Yeah. I'm still waiting, and it's always varying degrees, right? It's everything from just there's this one little thing out of place over here to we got an issue over here. Okay, but the time to have that discussion with your lawyer, whether it's us or somebody else, is at the beginning of the case.
Yeah.
Not at your deposition.
Not at mediation.
Not a mediation.
Yeah.
Not when we get through mandatory disclosures and then we get hit with a motion for sanctions for incomplete mandatory disclosures, and we're reading it and this doesn't make any sense. I've worked with Marcus for a year and a half now, and he never said anything about an Amex Platinum credit card. And then I call, dude, was this like a mistake or something? Oh, they found out about that? Okay, here's what the issue is. Yes, they found out about it because they're going to find out about it. All right. Had you just told us that a year and a half ago, we could have looked you in the eye and said, there's going to be an issue. And since it is going to be an issue, here's what we can do. Cut your losses here, cut your losses here. Admit that you effed up here. So you just got to, own up to it, and it is what it is. And here's what we can do. Here's how we can work around it. Or we can look you in the eye and be like, dude, it's not a big deal that you were having an affair as it relates to the equitable distribution. Stop stressing out about it. Now, maybe you're going to get some nasty text messages or something. That's different. But inside the actual context of the case, not a big deal. If we know about it from the start, then we can handle it accordingly. And we can either tell you if it's a big deal or not. And if it is a big deal, then we can come up with a strategy for it. How to mitigate the risk. And it might be just accepting that it's there and just, hey, there's not much we can do about it. This is how it's going to play out. At least you know. The other side's going to find out about it. So if you're having that affair, if you do have that apartment with your sugar mama, you want to let your attorney know about that sooner rather than later. And remember, any conversation you have with your attorney is subject to the attorney-client privilege, which means that you can just speak freely, openly. You can tell your attorney anything you want, and they can't repeat it, with very, very, very few exceptions, which are you don't even want to get into, bad exceptions. As long as it's just a conversation, you and your attorney, there's nothing for you to be worried about. Just don't talk about committing a felony or a fraud or anything like that. That's where it starts getting messy. Yeah. But if it's just,
and let me
good.
Yeah, and then just to wrap things up here with the mandatory disclosure, there are limited situations in which we can waive, if both parties are willing to waive mandatory disclosure in a divorce, both parties can waive having to disclose all of their finances. However, you cannot waive the financial affidavit, especially when there are children involved, because the court needs to see the financial affidavits and the child support guidelines, or else it's reversible error. Essentially, they get appealed. The divorce is going to get kicked back. It's not going to be a valid divorce if it gets entered. So judges aren't going to do it. So you still need to come up with the financial affidavit at a minimum. I never think it's a good idea to waive mandatory disclosure. That's my professional opinion. I don't know if Brian agrees with that, but I don't think it's ever smart to waive mandatory disclosure. You just never know what you can. I mean, obviously, if you're getting divorced, you probably don't trust your spouse that much, but it doesn't matter what your relationship is with them. Everybody benefits from the finances being disclosed. So with that, I don't know if Brian wants to touch on disclosure, and then we can wrap it up.
No, I mean, I think you said, I don't really think that you should waive mandatory financial disclosure with very few exceptions. I think if you and your spouse get along just fine, but, don't really want to be married anymore, and you've been married for 2 years, and, there's one checking account, and, maybe that might be a case where you want to waive it, but it's not going to move the needle if you do it or not in a case like that. So, I would say it's probably not necessarily, I would not waive it. Unless you just don't care. If you literally just don't care, you and your spouse just don't want to be married anymore, and you just want to take your money and she can take hers, or he can take hers or whatever, that's fine. But if there's any, I think that they might have this, or I think you want to do it. That's what it's there for. That's the benefit to it is to give you full and complete disclosure.
Yeah, and in a subsequent podcast, we'll talk about what happens if your case doesn't settle at mediation, and we'll take it from there. But that will wrap up today's episode. If anybody out there is contemplating a divorce, they live in Florida, they're on the fence about it, or they've been served with divorce paperwork, you can reach out to our office. We offer free 15-minute consultations. We're willing to speak with you, hear your side of things, and talk to you about how we can help you out or how we can be involved in the case, we'd love to hear from you. Our phone number is 954-388-0646. You can also look us up online, Fairway Law Group.
Absolutely.
Hire us before your spouse does.